You told me 10, so I'm sticking with 10. My father, I'm prepared to be disappointed. That's what I'm prepared.
Good afternoon. What a great day to be a Kiwanian, and it's good to see all of you here. I have one quick fun fact while you're standing up. On February 10th, there was a chess game. Does anybody know what happened or what's significant on this date a few years ago? That's it. The IBM, Deep Blue, you're exactly right. So get an extra piece of chocolate for Lee Parker right here in the front. So IBM supercomputer Deep Blue defeated Gary, that's exactly right, in chess. Good job, Lee. I knew you were going to ask me what year. Does anybody remember that? I was thinking it was 1984, but I might be wrong about that. Okay, thank you. We'll check. So can we join together and say our defining statement? Kiwanis is a global organization of volunteers dedicated to improving the world, one child and one community at a time. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Clay, would you lead us in song today?
In 1814, a fellow by the name of Francis Scott Key, a lawyer and part-time poet, was on board a frigate which was used for prisoner exchange. He was in the harbor at Baltimore. The English were shelling Fort McHenry. He was watching. All through the night, he was watching what would happen in the morning with the American flag. He saw it, and he had a piece of paper in his coat and a pencil or something that he could write on, and he proceeded to write a poem. And that poem is set to music now, and it's called The Star-Spangled Banner. So please join me. My country 'tis That's a test. The Star-Spangled Banner. Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Thank you, Clay. Way to keep us on our toes. Yes. Gwen, will you please share our invocation with us?
Let us pray. Dear God of compassion and justice, hear our voices. Help us recognize the privilege of gathering here today with friends and the opportunities available to improve the lives of children. Teach us what it means to come to you with the purity, innocence, and expectation of a child. Teach us to be servants of all. Guide us in your way of humility and service. Show us how to become followers. We ask for blessings on all your children the world over, and to bless this food to our use and us to your service. Amen.
Thank you, Gwen. Buck, will you start with guest and the membership welfare?
Sure. Good afternoon. Appreciate everybody being here today. We've got a number of guests with us today. Let me start with one of our new members who brought a guest, and that's Hall Edwards.
I've got with me John Stilley. John's originally from Enfield. He now lives in Raleigh with his wife Sterling, and he is in the insurance business.
We're glad to have you with us, and this is your first visit of 3. Come back 2 more times, and we'll talk to you about being a member, okay? We'd love it. Okay, Robert Cooper has a guest.
Stand up, Robbie. It's my pleasure to have Robbie Wooten here. He retired from NC State. I'm sorry. Robbie Wooten retired from NC State in the horticulture department, and he works with his sister, Mary Lou, that owns Side Street, and he caters our parties at our house. He's married and a former Eagle Scout from what? Oh, okay. Excuse me. And grew up near Rocky Mount at West Edgecombe Community. Welcome, Robbie Wooten.
Welcome.
Robbie, we're glad to have you, and we look forward to having you back. Please do. We've got well, it's not a guest, but a member that hasn't been here in a while because of the pandemic. But Craig Madden is back with us today. This is the first time since pre-pandemic. Let's give him a round of applause. Okay. He says he's a great guy. How about, do we have any membership welfare items from anybody in the audience? Oh, I'm sorry, you have a guest. I apologize.
Fellow Kiwanis, I'd like to introduce a friend of mine. John, if you'll stand up. This is a very good friend of mine who used to live here in Raleigh. He's now moved to Texas. And a little human interest story on John. John Brown had a twin brother. John met Joan. Joan had a twin sister. Joan, before she was married, was Joan Brown. So when John and Joan got married, they were she was Joan Brown Brown.
Oh,
So that's the end of that story.
all right. Well, welcome. Welcome.
Any other members have any announcements or any membership welfare items you need to share with the membership? If not, bless you all. Glad you're here today.
Yep. And the birthdays are on the board. So happy birthday to those that are with us. And I want to welcome our John from Enfield, our John from Texas, and our Robbie from West Edgecombe. And I have to tell you, I'm from Eastern North Carolina. I'm from right next door to where Robbie was. And now I think he and I are neighbors now. I live out toward the North Raleigh area. So good to have you.
Stacy, I've got one other announcement.
Oh,
We've got
sorry.
someone back with us today, a longtime member and a good friend, Gary Pendleton,
Hey,
who
Gary.
has been absent, and we did announce your brother's death while you were gone. We're glad you're back with us.
Yeah, you let us know how to support you. So then we have a few announcements. If you were on the board, met last night, a great board meeting. If you currently serve on our board, would you please stand up? So if anybody has any ideas, recommendations, or improvements, please see one of our board members so we can discuss that. Oh, did I not say that? Oh, or complaints. Please let us know. We want to hear from you. They're doing some good work, hard work, and we appreciate it, and we appreciate your support. We do have 5 new members who were approved last night. I'm going to ask them to stand. Bob Lippard, Bill Burlington, Lynn, Roger, and we want to welcome them. I think Macy couldn't make it, but hopefully she'll be here next time. We have our orientation. There's a number of people during COVID who did not make it to orientation. So orientation, I said Lynn. And so orientation is this Thursday night. So please sign on to Zoom. There are about 6 other members that are going to join our new 5, so we should have 10 people in that new orientation class. And there's a little secret. When you go to orientation, you take off the new. Well, there's a couple of things you have to do. You have to be a greeter for 3 times. You have to go to orientation. You have to visit a board meeting, and then you get to take off the new on your name tag. So we can see you. We hope you come do those things so you can be a part of the club as a whole. We do need greeters for next week. So who would be willing to greet next week? Oh, I got Bill and Bob. I think anybody else able to greet next week? You have to do it 3 times, but you're out of town next week. But okay, Bill and Bob. Sorry. That sounds fantastic. Thank you. Check your weekly updates for upcoming information. There's good information in those. We're going to start adding some links because for example, when we have the urban ministry or the diaper drive, we're going to add links to those agencies so that you can make donations directly or you can bring them here to our meeting. So Salvation Army is Friday, February the 24th from 4:30 to 6:30. We have 2 members that have committed to volunteer, being Bob Goodell and Courtney. We need 1 more member. Anybody willing to go serve at the Salvation Army? It's a wonderful evening, a great way to start the weekend. Ooh, I can hear crickets. How much, do I have some more chocolate? Can we keep passing that chocolate around? It is on Friday, February the 24th from 4:30 to 6:30. Yeah, okay. Well, I will be happy to do that, but if anyone would like to, let us know. We'd love to have you. Charter night is April 28th. More information to come. Andy, are you here? Is there anything else you'd like to announce about the golf tournament coming up?
Sign up. Anybody wants to volunteer? Feel free. In the email, whatever. You probably might put the volunteers. Other than that, the day for it, mark the calendar, invite all your friends and family.
Fantastic. Thank you, Anthony, for sharing that. The Action Club is actually the Saturday of the 25th. We'll be going to the North Carolina Museum of Natural Sciences. Downtown, we'll meet at 10 o'clock. We would welcome all and any Kiwanis that would like to join us, and then we'll all go to lunch afterwards. So mark your calendar. Nick, would you introduce our speaker today?
Well, last week we heard all about death and dying, and Robert over there wanted to know about having his ashes dumped in the river, and I got to thinking, yeah, we can put those ashes in the Cape Fear River, and with all those forever chemicals, maybe it gets eternal life out of the deal. So I don't know, and then I thought, well, they could shoot mine through that Russian spy balloon, that Chinese spy balloon, and get my burial at sea that way. But Buck Lattimore, he's gone from death and dying last week to estate planning this week. So, you have to worry about a guy who's that focused on the end of life. I must say, and this is not a promo for our law firm, because Buck has gone out of his way to line up my competitor and adversary to be the speaker next week. But anyhow, we're lucky to have Stephen Brown here to speak today. I was looking at some of the papers he's written and stuff, and I paraphrase loosely. You can learn today what to do about that worthless son-in-law who is allergic to anything with the word work in it. You can find out what to do if your spouse leaves everything she has to the concierge doctor and the landscape guy. So there's plenty to be thought about as y'all listen to this talk. Stephen Brown has been with our firm since 2011. The only mistake he made was starting at another firm for a few years before that, but he quickly saw the error of his ways. And he's a great guy and a great lawyer, as you're going to hear in a moment. He got a double degree from UNCG, and one in piano performance, the other in political science. Then he got his JD from UNC in 2008. As I said, he came to Young Moore in 2011. He became a specialist recognized by the state bar in estate planning in 2018. That essentially means taking almost another bar exam. His wife was a longtime music teacher, and among other things, he was the lead pianist at his church for 8 years. At this point, when he's not working, he is probably chauffeuring one of his 3 girls, whether it's horseback riding, gymnastics, ballet, basketball. He is at that stage in his life. Anyway, you're going to get to hear a lot of good stuff. We got a great PowerPoint, and I won't take any more of your time, Stephen.
All right. Well, we're going to keep you on the edge of your seat today, talking about death, and we might even throw in some taxes. So I think I'll be excited about that. Great. So in all honesty, you know, estate planning is one of those adult conversations you have to have. And so we're going to have that conversation a bit today. As we're talking through it, if you have a question, just ask me, because I want this to be educational for you. I want this to be kind of with an understanding it's going to be a top level type of conversation. When we talk about estate planning, people's lives are complex. Their property interests are complex. Their family dynamics are complex. And estate planning has to deal with all of those things. And so the rules are complex, and there's a lot of different things to think about. So as we start this conversation, it's important to narrow the scope of what we mean by estate planning, because I often have people come in and they have different ideas about what that means or doesn't mean. But if you really boil it down to its essence, what we're doing is trying to plan for the prudent administration of your affairs and your assets in the event you become incapacitated or you die, okay? And I know that just lifted the spirits of everyone in the room. And so a lady asked me the other day, said, how do you do this all day long? And I said, sometimes I question that too. So we're going to talk through, like I said, this is top level. There's a lot of complexity, but what I want you to take away from this conversation is basically a checklist for yourself to make sure you have covered your bases. Maybe you have a family member who needs to think about these things too. Because this matters. If you will eventually, most people during their lifetime have an event of incapacity, for example. That's where we're going to start. Maybe that's for a couple days, maybe that's for a few weeks, maybe that's for a period of years. But you have to stop and think through basic questions. And the first question is, who is authorized to make decisions on your behalf when you're incapacitated? Okay, it's a basic question. And there's really 3 ways people get that authorization, okay? There's 2 ways which I don't think are the best approaches, and 1 way I think is the best approach. But you need to know that there are essentially 3 ways. The first way is if you don't do any affirmative planning and you have an incapacity event, there's nobody authorized, well, we can go to the court, and I know Bill Burlington's here, and so he can tell you all about this. But you can go to the court, you can have somebody declared incompetent, and then you can appoint a guardian who will be a court-appointed guardian for them. There'll be a guardian of the estate that handles their assets and guardian of the person that handles their affairs. And now that process is all before the court. They have to file accountings and get bonded and go through a lot of process. That is not private process. That's not necessarily an efficient process that you want to find yourself in, but it is there and an option. That's the default. That's what we'd like to avoid. So in order to avoid that, the next kind of category up from that is some people do what I call piecemeal authorization. And most of the time what I have is people come in my office and mom or dad wants some help on ministering affairs. And so what they do is they put a child on a bank account with them, right? That's a good idea because now the child can write checks and they got access and they're handling things, and it effectuated that purpose. The child can write checks on the bank account. But what about the retirement account? What about the house? What about calling the utility companies? What about all the other aspects of their life? The child's not authorized to enter that space because they're only authorized on the bank account. So that piecemeal kind of way of going about and doing it, sometimes that's what you run into, but it's not comprehensive. Also, it can have very unintended consequences. That joint bank account that they put the child on is probably joint with right of survivorship. So when mom or dad die, that asset's going to go to that child, much to the dismay of the other children, you know. And so those types of approaches are not generally the best. Usually what we recommend is the third option here, and that's that you appoint an agent to do things on your behalf. This is very basic. You need to have a power of attorney. Sometimes it goes by general power of attorney or financial power of attorney or durable power of attorney. They all function essentially the same way. And they're to help have somebody in place to administer your assets for you, okay, if you can't do that yourself. You also have a healthcare power of attorney. That person handles your medical decisions for you. Very basic, right? You want to have a primary person and at least one successor named, okay? You people print these off the internet. I mean, this is one of those things that's at its core, everybody needs to have in place. But you can't stop the inquiry there. You got to think about the next question, and that is, well, I've appointed somebody, but what's the scope of authority that I've given that person? And this is where it gets a little bit more complicated, because I run into at times where people have given too much authority or not enough authority in documents that they've come up with. And for example, if you want somebody to have the ability to engage in gift giving on your behalf, maybe that's a good thing. Maybe they need to do some Medicaid planning for you, or they need to give away for some tax reasons some assets. But that has to be expressly stated in a power of attorney. And then you even need to go farther and perhaps name that they can give it to themselves if they're agents. Maybe you want to allow them to change beneficiary designations or make trust amendments to a irrevocable trust or engage in certain type of business planning. All of those things need to be addressed in a power of attorney. And I've seen at times that where things that people have don't go far enough or are not catered to their specific situation. With healthcare powers of attorney, it's essentially the same inquiry. You want to make sure that you have customized that power of attorney as you deem appropriate. You can say that an agent doesn't have the ability to do a certain type of procedure or remove life-prolonging measures. Also, it's your healthcare agent who has the ability to determine whether or not you're going to be buried or cremated, unless you've given some other specific direction somewhere else. Most people don't know that, but it's your healthcare agent who decides that issue. Now, I've had situations where people have named multiple children, like as a healthcare agent, and those children don't get along about anything, and poor mom is sitting there, she's passed away, they won't decide whether she's been buried or cremated, and all I could think about was, she'd roll over in her grave if she knew they were arguing about this, but we can't even get her to her grave. And so, those are the types of things that you've got to think through, because then that's about how these things function once you get them in place. That's the basic things you need to have in place for incapacity. It doesn't matter if you have $10,000 or $100 million. At its core, it's going to be the same principle. Now, I'm going to say one thing about this, just because I tend to see this happening more and more. If you understand these rules apply to anyone who's an adult. So if you have a child that's a young adult, 18 and off in school, you no longer have the ability to automatically make decisions for them like you did when they were a minor. You need to consider getting them some powers of attorney in place. It's just kind of a basic thing. You want to make sure that that's covered. I'm going to transition away from incapacity and spend the rest of the time talking about what happens when you pass away. And because I think there's a lot of confusion in this area. Understand the first thing is when you pass away, a new set of rules takes over, essentially. Those powers of attorney that you did, particularly the power of attorney to handle assets, that becomes ineffective at that point. That power of attorney has no more authorization to do anything on behalf of your estate. The healthcare power of attorney, of course, you're deceased, so they're not making medical decisions, but they do have that small ability to direct burial or cremation if you've given that authority in the document. Other than that small pour over, all those documents are now over, and now a new set of rules takes over. And of course, when somebody's thinking about planning for death, they're generally thinking about 4 basic goals. Number 1 is they want to efficiently and privately transfer those assets, right? We all want to keep things simple, and that's not a bad objective to do. We want to get things as quickly as we can to the beneficiary. We don't want to have a lot of costs and expense and time delay in doing that. We certainly don't want to splatter how many assets you have all over the public records or all over a billboard somewhere. So that's number 1 priority of most people. The second is we want to get the beneficiaries their assets. We want to protect those people. There are circumstances that automatically kind of click in your mind that maybe you got to think through a little bit more about that. If you're in a blended family, lots of people are, you have children by prior marriages, You got to think through harder about that. I mean, I've had the unfortunate phone calls more than once in my career where people have called and asked me, what can they do? Dad passed away, left everything to stepmom. Stepmom passed away a couple years later, left everything to her children. They get nothing. What can they do about that? My response is, after some conversation, nothing. Because he left everything to your stepmother. It was her assets to do with what she pleased. So there has to be some thought in blended family situations about that. Also, if you have beneficiaries who are spendthrifts or have creditors or special needs beneficiaries, we don't want to disqualify them from their governmental benefits. Also, if you just have minor beneficiaries, you're probably going to be using some form of trust structure to hold assets for those people. You might also just have special assets that need special attention in your plan. If there's a family-owned business involved, I mean, we all know families that work together stay together, right? Yes, so you've got to think through that. The kids, while we like to think our kids are going to harmoniously live together and work together, and that's probably not quite how it's going to work. You need to think through who's working in the business, who's not, who's in charge. You need to put some parameters in place. Family-owned businesses are very important to think through, but also just real property. If you own a residence, most of you probably, if you have a will, your will probably says, I'll leave my property to my children when I die, or something like that. And if it does, and you own a residence, the way the law treats that is it vests in those heirs, if you've just said it like that in your will. Now, if let's say you have 4 children, do you know what's happened with your residence? Now it's owned fractionally by 4 different people. And those 4 people have to decide on what to do with it, when to sell it, for what price to sell it. Now, maybe they'll all get along and that won't be a problem, but if they don't, they're going to end up in court arguing about a partition of how to do that. Your executor doesn't just have the right to sell it unless you've done some special things in your documents, okay? So real property is another consideration. Another one that comes up pretty regularly, I've loaned money to a kid, they owe me money, or I've advanced money, I've given them something, I want to offset it. You got to address all of those things in your documents. Other people just want to give money to charity. It's a good thing to do, but there's efficient ways to do that, to make sure your purposes are carried out, make sure certain tax things are addressed. Finally, and another one we'll talk to a little bit later is just about taxes, right? People are concerned about the tax man, and that can be a very serious concern. But the place to really start when you're thinking about your assets is to understand how assets transfer when you pass away. Because oftentimes I have people walk in and they say to me, Stephen, I need a will. And I'll say, well, you probably do need a will. That's a necessary part of your plan, but that's only a part of your plan. It's not a sufficient thing in and of itself in most people's situation, because your will really only governs probate transfers. Most people's assets nowadays go by non-probate transfers. So we have to think more broadly than the will when we're talking about somebody's estate planning. And so it's important to know when you're thinking about what path you're going to go down, how we determine that. And when I say probate or non-probate, understand when I say probate, for our purposes today, just think about it as the court. The court's involved in that process. Non-probate means the court's not involved, usually because there's a mechanism in place where we know who's getting the asset, and there's somebody responsible to get that asset to that person without the court getting involved. Non-probate transfers, like I said, most people's assets transfer through this process. And how do you achieve non-probate transfer status? Well, it's usually one of 3 ways. First is through how an asset is titled. And this is really important because I think there's some confusion about this. So if an asset is jointly held with right of survivorship, that asset passes automatically to the joint owner. So most commonly you have a bank account, it's a joint bank account. Probably when you signed up for it, they made it with right of survivorship. And that means whatever's in that account will go to the surviving person on the first joint owner's death. Real estate can be held that way. Personal property can be held that way. But not all joint assets are joint with right of survivorship. For example, most common one, do you own a car with your spouse and have both your names on it? Commonly we run into that. In order for that to be joint with right of survivorship, the title has to have something extra on there that says that. And I've only ran into that twice in my career where somebody had actually done it. One of those is in my own. So it's very rare to see that, okay? So Not everything's joint with right of survivorship. Not all bank accounts are joint with right of survivorship. Not all brokerage accounts are joint with right of survivorship. So, but asset titling is the first way. The second way is through a beneficiary form. We're all familiar with those. That's where you've contracted with that institution to pay those benefits to the people that you've named. They come in different forms: transfer on death on a bank account, payable on death on a securities account, or a beneficiary designation form on an IRA or life insurance, okay? They all do functionally the same thing, okay? You name a beneficiary, they receive, that institution will pay those benefits to that beneficiary. Really important concept to remember in this is if you name a beneficiary of a policy, for example, and you say, I hereby give it to my child, and my child's 3 years old, but I've got a trust set up that I really wanted it to go into, you've named the child as the beneficiary. Essentially what you're doing with beneficiary forms is you're writing little wills through each one of your beneficiary designation forms. The final way, and probably again the universal way that people kind of address non-probate transfers, is through irrevocable trusts. I do a lot of trusts. There are a lot of different kinds of trusts done for a lot of different reasons. But the most basic form of trust is irrevocable trust. Sometimes it gets called a living trust. But really what it means is that somebody puts assets in trust. They're the trustee of their own trust, usually. They have a right to revoke it, amend it, or change it anytime they want to during their lifetime. And when they die, it becomes irrevocable, meaning it shouldn't be really changed at that point, and the assets go to whomever the trust says to give it to. Well, if you think about it, what does that sound like? Beneficiary form, right? In effect. So you can put assets in there, and it can be as simple as, when I die, I leave all my assets to my children. Well, that looks just like the beneficiary form in many ways. And so revocable trusts at their core are a way to avoid the probate process, and many people use those for privacy purposes. Again, it's really important for business owners to put their businesses inside of these trusts for privacy purposes. If you have an asset that's not a non-probate transfer, it's a probate transfer. And to be clear, that means that you have an asset, we don't know who gets it unless we go to the court and ask the court who gets it. If you have a will, the court will say give it to the person in the will. If you don't have a will, there's a set of rules that apply called intestate succession. That's where the law writes a will for you. And let me be clear, it doesn't work the way you think, particularly men. If you have children out of wedlock, which a lot, that's becoming more of a thing, you will have very upset expectations about how that works probably. So don't rely on that. You want to have a will, because it's, again, kind of catching anything that didn't go through a non-probate transfer. I also put on here these statutory transfers. Here's a little takeaway, okay? Going back to the blended family situation. You can go home and kid your spouse that no matter what they do in their will, unless you have waived that in writing, you have the right to the first $60,000 of their estate. It's called a spousal years allowance, and they can file something and get it. You also have the right to an elective share of their estate, which is a percentage of their overall assets, whether it passed through non-probate or probate, if you so desire that. So if they try to disinherit you, I'll just let you know you have that. So just those types of things are also involved with court, so I think it's important to keep them under there. And it's the type of thing that you have to kind of plan for. So basically what you generally end up with in a basic estate plan is a will, oftentimes a trust, a revocable trust, powers of attorney, healthcare power of attorney, and a general power of attorney for financial management. That's just kind of a core part of an estate plan. Then you have to think about, particularly at death, who's in charge of that. And this often causes confusion because you've got a lot of different people that might be wearing different hats with different authority. And most commonly, it's a mix of this group right here. The first one is the personal representative of the estate. Now, what that means is, if you have a will, you probably name somebody called the executor, and they're going to execute the terms of the will, okay? Just a little tidbit, just because you have a will where somebody names you an executor, you're not the executor yet, okay? The will has to be filed, and then the court has to appoint you as the executor, okay? If you don't have a will, or the will doesn't name an executor, you end up with an administrator. But essentially they do the same thing. That's a personal representative of the estate. That person handles the probate process, files taxes, files estate taxes if they need to do that. They pay creditors. They're the ones in charge of that. But here's the deal. You only need to open an estate if there's something to be done through the court process. I'm going this afternoon to meet with somebody. We were talking yesterday, and I'm very happy to go tell them this afternoon, you don't need to open an estate, okay? Because everything's passing another way. We don't have to go through that part of the process. You might also have the healthcare agent who's making those burial and cremation decisions. Just keep in mind, they're the ones who have the priority on that in most cases. You have a trustee of the trust. They're wearing that hat. They might have to interact with a personal representative, but they are in charge of the trust assets. You might also have a guardian for a minor child involved. If it's parents that have passed away and they had a minor child, the court, in your will, the parent's will, they can nominate someone to be a guardian, and then ultimately the court will likely appoint that person as guardian. That would be the person in charge of a minor child. So you can have a lot of different people involved in an administration. Sometimes the same person is wearing all these hats. It's just they have different capacities they're acting in. Now, one of the practical things that you've got to remember is once you've done an estate plan, you are not finished. And this is a big problem that I'm seeing come up, is that people do documents, they do powers of attorney and a will and elaborate revocable trusts and all the things that they need to have the legal bells and whistles. But one of the things they didn't do was actually equip their fiduciaries, the people that have been named, to seamlessly step into their shoes in an event of capacity or at death. And so one of the things I ask people to consider doing is something called a memorandum of instruction. That's just my term. Call it a letter of instruction, call it a letter you write, it doesn't matter. But it contains certain information, because I can't tell you the number of times somebody's had an event and then their children are looking around to figure out what life insurance policies they had, where they banked. Oh, I think there was some stock that they had somewhere, and it just turns into a nightmare as they try to hunt it down. So here's what you want to do. You want to identify your assets and your advisors. You want to provide access to those assets. And right now, one of the bigger things that's coming up is with digital things. So y'all probably have phones, probably password protected. Who has that password? If something happens to you, I've had really sad situations. We couldn't get into people's phones. And I had one situation with a husband and wife. They'd just gone on a trip. Husband passed away the day they got back unexpectedly. He had tons of pictures on the phone, and it was very, very difficult to get into that phone. No one knew the password. So understand that you can make life easier. Think about those instructions about memorial services and burial and how many hymns you want sung and who do you want to invite, who you not want to invite. I mean, all of those things you need to say, because people got to figure that out really quickly after you pass away, and you can make it seamless. If you really want a cathartic experience, sit down and write your own obituary. I serve when people don't have anybody else and their clients, and it's an appropriate circumstance, we'll serve as their power of attorney and things. But one of the things I ask them to do is write an obituary. And so it can be an interesting thing to read for people who've written wrong. You also want to, if you have multiple beneficiaries who are going to share your tangible personal property, which is your furniture and your jewelry and things like that tend to have more sentimental value than monetary value, hey, we can't divide your rings, okay? We can melt them down. Yeah, in litigation, that might actually happen. But, we can do things like that, but you don't want that to happen. So go ahead and say, I would like the engagement ring to this child. I'd like the earrings to that child. I'd like the coffee table here, whatever you think is particularly important. Finally, with the understanding that the things you're saying are precatory, meaning that they're your request, this is not a will, you're not binding the hands of people. I have minor children. It's very important to me, if something happened to both me and my wife, that I've given guidance to the trustee about what I want them to do. Now, they have discretion about whether or not to follow that, but I don't want to rely on a conversation I had after dinner one night for them to remember all the things I wanted for my kids. So I put some things in there. For example, I want my kids raised in a particular religious faith. I want them to have certain things when they get to certain milestones, if those things are appropriate. Those things you can put in writing, and I think it's important to do that to help guide people in some expectations. Now, in the few minutes that we have left, I'm going to dare say it, we're going to talk a little bit about taxes. I spend a lot of time talking about taxes. with folks. In some cases, it's a quick conversation because they don't need to worry about it. In other conversations, it's a major conversation. And so the goal today is not to get in all the weeds of all the taxes, but to basically give you an oversight of what you should be thinking about. And here are the main ones that you got to think about when you're thinking about estate planning. Income tax, of course, is one form of tax. You're all working on that diligently right now, I'm sure, your returns. Wealth transfer taxes. And then also sometimes we have to think about property taxes, particularly if people own lots of agricultural land and that kind of thing. We're not going to get into property tax today. Income taxes, though, is a big one. Understand your heirs do not pay tax just because they are gifted something from you or they inherit from you. Okay, that's excluded. That's not income tax. That's not an income tax event. However, there are consequences when you leave things at death to people, and one of those is the step up or step down in tax basis. How many people are familiar with that? How many people have benefited? Now, don't answer that, but it's the biggest tax giveaway there is, okay? It's something about a little over a year ago now that this was part of the tax conversation when they were thinking about changing the law, was taking away the step up in tax basis. Well, I'll give you an example to demonstrate this. If I had a lady come in who was 92 years old, who bought public utility stocks back in the 50s and still owned them, and they were worth a ton of money, and she loved her dividends, but she was ready to give some of that stock to her children. And so she thankfully asked before she did that. And I said, no, please don't do that. Why not? I just want my kids to have some. Don't give them the stock. Why not? Because when she passes away, all of that appreciated gain will go away. Poof. But if she gave it to the kids, what happens? Oh yeah, that's right. Now they take her basis, and when they sell it, they pay all the tax. So you got to keep those in mind. Also remember that there's a step down in tax basis. That does come up at times where people have large losses. Just go away when they die. So it can work against you if you happen to be in that situation. Another big one is because a lot of people have their assets inside of tax-deferred retirement accounts. So 401ks, IRAs, traditional ones, not the Roth, but the traditional ones, when you take that money out, you're all aware of this. They've changed all the rules. They keep moving the ages around, right? So now you got to be at the ripe age of 73, I think, coming up before your required minimum distributions start. Well, when you leave those assets to your heirs, certain heirs get a better deal than others. Okay, that's the way that the law has rewritten that. And it needs to be done a certain way. And so sometimes you need to be very thoughtful about who you're leaving those retirement accounts to. Maybe this heir gets a better deal by leaving the retirement account than this one. And so there's some things to think about. The final income tax thing that I kind of see mucked up a little bit at times is in people's documents, they often leave a bequest to charity. $10,000 or more, it's a nice little gift that they make. First of all, as a general rule, it's better to leave assets to charity during your lifetime for tax purposes, but assuming you do at death, your estate or your trust will not get a charitable deduction for that unless you've said more than just leave them this money. During your lifetime, you can leave assets to charity, and just because you gave it, you should get the deduction. In an estate or trust, there has to be more involved in that, or there won't be a deduction for income tax purposes for that, okay? That gets us to wealth transfer tax. People are terrified of these taxes. Most people don't need to be terrified of these taxes. So wealth transfer tax, the way it works is the federal government basically says, look, we're going to allow you to give away assets either during your life or at death, and we're going to look at that in the aggregate, but if you go over a certain amount, we're going to tax that excess amount at 40%. It used to be back in the 90s, late 90s, that amount was $600,000. So if you owned a house and a life insurance policy, you had a state tax concern. Nowadays, per person today, you have to have more than $12,920,000. Now, there are people that certainly have that problem, and it's a good problem to have. But if you don't find yourself in that situation, then you don't have an estate tax concern. Now, that threshold amount moves back and forth, okay? Right now, it's the highest essentially it's ever been. In 2026, January 1st, 2026, it's scheduled to reduce in half the amount that it has. So instead of $12,920,000 it adjusts for inflation every year, you'd have about half of that at that point. So if you find yourself in that category, then yeah, you need to do some estate tax planning. You can think of a situation where an individual has illiquid assets. They own a lot of real estate, right? Well, they pass away and they have a estate tax problem. We have to come up with a way to pay that bill because it's due 9 months from the date of death. And so that can be a real concern for people. We spend a lot of time talking to folks about that who are in that circumstance. But you can't end there with this equation. Sometimes that's the problem. People stop there and they think, I don't have any federal issue, and so I'm fine. You also have to think about state, estate, or inheritance taxes. Now, North Carolina doesn't have any, so we're good. But what if you have assets in New Jersey or Pennsylvania or New York or some of the other states, particularly northern states? If you do, they have inheritance taxes. They have certain taxes that can apply. And so you'd want to think about that. I recently had a conversation with somebody about a pretty valuable beach property in New Jersey, and we thought maybe it's time to think about moving that investment somewhere else. But there's also now this concept of wealth taxes. I don't know if anybody's heard about those, but they've existed in Europe. They've existed in other places. Some states are considering them. These are for really high net worth people, where basically they tax you on the amount that you owe, the amount that you own every year. So it's like an estate tax that applies every single year over a certain threshold. That's really only the mega wealthy that would be affected by that. I purposefully am going to stop a little early because I thought somebody might have a question. So I've kept this extremely top level. And so I'm going to open it up for questions to see if anybody has any.
I just got a check, a large check for the estate of my mother, and it's written to the estate of Grace Boone. I went to the bank to cash it, they won't let me cash it. I am power of attorney, but my son-in-law is trustee of all the estate and the trusts and all that stuff. How do you get it to cash it?
So if there's an executor appointed of the estate, then that would be payable to the executor would take it and put it in an estate account that they had somewhere. But it sounds like maybe that no executor's ever been appointed because there wasn't a need to set up that. Is that correct?
Well, he's handled all the financial stuff, so I'm not sure.
Yeah, the question I would have is whether he had been appointed the executor, and if he had, he could put that check into the estate account, and because it's payable to her estate, and that check would then become part of the estate assets, and that's part of a probate estate because of the way it got paid. Then he should distribute that money right back to the beneficiary, and if that's you, then you're the right person to get it. He can make a distribution out of the account.
You've covered these three subjects, but I think we ought to spend a little more time on it. I've been doing financial planning and working with numerous tax and estate planning attorneys for 46 years. Here are the major things that I think people in this club and everybody needs to know. You mentioned a grave plot, and I never paid much attention to it. About 25 years ago, I had a client whose daughter died at age 15 of cancer. He said the hardest thing about that was we had all these things to do with planning a funeral, but we didn't have grave plots. So I had to rush out and buy grave plots, where maybe it turned out it ain't where I wanted it. Too late then. So I've told everybody since then to go buy them, not tomorrow, go buy them today. And then the other thing is, you mentioned these two. Would you say a little bit more about special needs children and about, go ahead and answer that.
Yeah, so it is really critical that if you have a special needs beneficiary, child, grandchild, whatever that is, that you have left those assets in some form of trust for them that understands and contemplates that they're going to be on some form of governmental benefit. If you leave assets outright to them, it jeopardizes those governmental benefits. Now, there might be ways to correct that depending upon their age, but that costs time and money. And so you need to consider that. It can impact them greatly and really cause a disruption in their Medicaid or their whatever types of benefits they might be getting. That is a good point.
The other one and final one is a child that's a spendthrift.
Yes. So as one who has had to, one who's had to have the experience of trying to find a beneficiary who was since traveling around the world to give them another $200,000 check, you absolutely need to think in advance about how is this money going to influence these people when they receive it? As a general rule, I tell clients, giving money, any large sum of money, and let me back up, because large sum of money has different meanings to different people. Most people in this room, if I said $100,000, some of you would say that's not a small amount of money, but you can't live on that forever, right? But to a 20-year-old, that's enough to drop out of school, and man, so think about when I say a large amount of money, what that means. You need to leave it into some form of trust. If they're a spendthrift, they probably got a creditor problem, like credit card bills or something. Assets you leave in trust for somebody else are generally creditor protected. So a creditor can't come get it from them, including a divorcing spouse. So those types of things are really critical tools at hand. And in actuality, in North Carolina, you can leave them in a trust where the beneficiary has a great deal of discretion. So if it wasn't a spendthrift, you're just trying to do creditor protection, you can give a beneficiary a lot of power over that trust, and it doesn't mess the creditor protection element up.
Talk about the ability of a IRA to be left to a charity as opposed to paying tax on it. For example, the Kiwanis Club.
Yes. You can absolutely and should. If you're going to make a charitable bequest, I have this conversation regularly where people are generous and they want to do something. They want to leave it to a scholarship fund, or they want to do something generous. Leave it out of an IRA, because that charitable beneficiary gets 100% of those dollars. You leave it to a beneficiary, they're going to pay tax on that amount. Okay. And so they're not getting all the dollars in there. So be efficient in where you're leaving those assets from. And there's ways to do that and make sure that they end up with exactly the amount of money that you wanted them to do. So yeah, that's a good point.
Assuming you set up one of these complex estate plans, trust, etc., and then you go home, you start writing these instructions to my executor, do you run into some point where that letter may be construed as a new will, revoking the prior?
You have to be careful about that. That is true. Usually what I provide to people says at the very top, these are precatory instructions only for your guidance. Yeah, if you go home and you start writing a document in your handwriting, if you do it on a computer, you don't have the same concern. But if you write it in your handwriting and you say in there, I really want my child to get $100,000 from my estate, there's an argument that would be a will that you've done. So you've got to be careful about that. And that's a good point. It's something that when you do a letter of instruction or something, you need to be
Second, a point of personal experience. If you go to a lawyer and you have a special need individual, make sure that lawyer understands the interaction with government benefits, because many lawyers don't.
That is true. It is a specialized area. And to be clear, there are estate planning lawyers. Oftentimes they involve some of those things, but there are also something called elder law attorneys. So particularly for older individuals who need to comply with Medicaid rules, that's the type of attorney you really want to go to for that type of thing. More experienced people.
Wiser.
Indeed.
So, Stephen, thank you so very much.
much.
Before you leave, can I get you to sign this book? We donate this through the school system for the reading program, and so you'll sign it. So thank you, Stephen. You've given us a lot to think about. That is a heavy topic, but what we have heard is to plan ahead. And as this is Valentine's week and we love our family, let's help them out by planning ahead, thinking ahead. And I'm sure you others have extra questions. Stephen, if you could stay a minute or two to answer those after the meeting, we'd appreciate that. John from Enfield, thank you for coming. John from Texas, please join us again when you're in town. And Robbie, please come back. We're super happy to have you. Wonderful club and community. Come join us. And we're also happy to see Craig back today. It's the first time he's been back since COVID, so we're happy to see you. February 17th, our next week, we'll have Jeff Gray from Bailey and Dixon speaking on the pros and cons of occupational licensure. Have a wonderful weekend and a happy Valentine's.